Mr. President.
Senator from the great state of Alaska.
Thank you, Mr. President. Mr. President, I've come to the floor this morning to speak on the resolution of disapproval that is before us, but I want to make just a few comments following my colleague, the minority whip, and I'm pleased to hear him say that he does look forward to the opportunity for hearing on Judge Gorsuch and the opportunity for a vote. I think we recognize that we have in front of us an individual who has truly a stellar legal reputation, an individual who has committed himself to the law in a remarkable way. When he was before this Senate for confirmation, moving up to the 10th Circuit, he enjoyed very strong support. And I would like to think that on yet further review of this very strong individual, that our colleagues will do the due diligence that is necessary, that is required as part of our role of advice and consent, and give that same show of support that they had previously. And I look forward to that. The comment was made, and there's so much that I will respond to at a later time when I go into more detail about my support for Judge Gorsuch and why I think that he is exactly the type of individual that we want to see named to the Supreme Court. But the comment has been made not only by my colleague from Illinois, but from others, that somehow or other Judge Gorsuch is for big business and not the little guy. And it seems that the criticism is based on this viewpoint that courts should not defer to federal agency interpretations of their own rules. And certainly big business is a frequent challenger of government overreach. But as you and I know, Mr. President, so are ordinary Americans, people like John Sturgeon, an Alaskan who really took on the federal government, took on the agencies, took on the Park Service because he was told he could not operate a hovercraft in an area that he had traditionally, historically, for decades, for years. And John Sturgeon, on his own, with the help of a few friends that came together and had everything from garage sales to help fund his litigation to just the generosity out of their own pockets, they took all the way to the Supreme Court the question of whether or not the Park Service's regulation had exceeded the legal authority. And I happen to believe very strongly that Judge Gorsuch is clearly on the right track here when he questions the deference that courts give to our government agencies. And I think most Alaskans would probably agree with us on this point, that when you're talking about the scales of justice, they should not be tipped in favor of our federal agencies. So again, I'm pleased to hear that the minority whip agrees that a filibuster is not appropriate, is not the way to proceed with this fine nominee, and I look forward to learning more about Judge Gorsuch, but also to be able to share more of my observations at a later point in time. I do want to speak this morning to join my colleagues in support of House Joint Resolution 38 to disapprove and nullify the Department of Interior's so-called stream protection rule. And I want to begin my comments by thanking Majority Leader McConnell and Senator Capito of West Virginia for sponsoring the Senate version of this resolution. I also want to note, Mr. President, that I'm proud to be with you as a co-sponsor on this bipartisan measure, 28 colleagues in support. Now, by name alone, the stream protection rule may sound pretty innocent, pretty well-intentioned. But as we have heard and as we will hear throughout this debate, the reality is really different. This regulation will have severe economic impacts. It will cost us jobs. It will cost us revenues, as well as affordable energy all across our country. So by way of background, the rule revises longstanding regulations for coal mining under the Surface Mining Control Act and Reclamation Act. Around here, we don't use that long title. We simply call it SMCRA. SMCRA was finalized in December of 2016. It took, excuse me, not SMCRA, but the rule was finalized in December of 2016. It took effect 2 weeks ago. It makes more than 400 changes to existing regulations. Now, 400 is just a number that shows the scope of the changes that the Obama administration has made here, but it hardly does justice to the sweeping substance of the changes or the deliberately opaque process that the Obama administration followed to make them. SMCRA is supposed to be an example of cooperative federalism, and many states have approved programs that allow them to regulate coal mining within their own borders. But beyond that, the law explicitly directs the federal government to work with states, to engage with them whenever any changes are made. So it requires that level of cooperation and collaboration. So what happened? The Obama administration chose to draft this rule behind closed doors. It ignored the input and the recommendations that were provided by states and other stakeholders. It subverted the law, basically, to meet its own policy objectives, which was to keep the coal in the ground. Ultimately, that's what they wanted to do. And it finalized a rule that will shut down coal mining in several regions in our country, including possibly in Alaska, if it is allowed to stand. Now, the Obama administration claimed that this rule would cost only $81 million a year and that it did not qualify as what is considered economically significant as a result of that. And we'll likely hear that number touted by some of the opponents of this resolution and probably some who will claim that we're exaggerating the impact. But I don't think that we should forget how the Obama administration determined that the rule was insignificant in the first place. In January of 2011, the Associated Press obtained documents showing that this rule was projected to eliminate 7,000 direct jobs across the country. So instead of going back and fixing the rule to avoid these potential job losses, what happens? The Department of Interior fired the independent contractor that had made the projection. So effectively, you have a situation where the department essentially cooks the books instead of fixing the rule. And it rebranded this then from the stream buffer zone rule to the stream protection rule. Again, sounds much more innocuous. So what the American people should know is that there is a real discrepancy between the economic impacts the Obama administration estimated and what other sources project will happen. The projection is up to 30% of the direct jobs in coal mining will be lost. Domestic coal production will fall 29 to 65%, anywhere from 15 billion to 29 billion in lost annual coal resource value, and 3.3 billion to 6.5 billion in lost state and federal revenue. So with estimates like this, it's no wonder that this rule has drawn such strong bipartisan opposition from Alaska all the way to Appalachia. And if you're doubting the statistics, if you're saying, well, they seem hearing things on one side, on another, you need to talk to the people out there. We did that. We did that. Instead of just taking what the Obama administration said, we went out and we asked people. Last March, I held a field hearing of the Energy and Natural Resources Committee, and we held the field hearing up in Fairbanks, Alaska. And among our witnesses was a woman by the name of Lorelei Simon. The occupant of the chair knows her well. She works for Usabelli Coal Mine, a family, initially family-owned and operated coal mine, very successful, but providing coal and power to the residents of the interior, and has been for a long time. And Ms. Simons spoke about how coal resources contribute significantly to our state by providing jobs and a reliable energy source. She explained that coal is the cheapest source of energy in interior Alaska for everything from the local community to our military bases there, how usability has helped to create business for others like our Alaska Railroad. And she also highlighted the broader picture about how coal strengthens our national and our energy security. So those are all good things in my book. But Lorelei also testified about the stream protection rule. And she said that if the rule was finalized as it was proposed, which it has been, she said it will likely kill all coal development in Alaska. She also noted that Congress passed SMCRA, but during the Obama administration, she said, we're seeing unelected federal employees violate legislative intent, which will kill America's coal industry. Now, Lorelei Simon is not alone in her criticisms or her opposition to this rule. Our governor in Alaska, an independent by the name of Governor Bill Walker, recently noted that it was one of the worst of many different actions the Obama administration took to limit resource development in our state of Alaska. The attorneys general of 14 different states wrote, and I quote, "The rule would have a disastrous effect on coal miners, their families, workers in affected industries, and their communities. It would also impose very significant costs on American consumers of electricity while undermining our nation's energy supply." It's pretty tough. Not only a disaster effect on the coal miners, but the costs on American consumers of electricity, undermining our nation's energy supply. The Interstate Mining Compact Commission described this rule as a burdensome and unlawful rule that usurps state authority as primary regulators of coal mining as intended by Congress under SMCRA, while also seeking to impose, quote, an unwarranted top-down, one-size-fits-all approach that does not take into account important regional and ecological differences. And then finally, the U.S. Chamber of Commerce noted that the rule, quote, exceeds the department's authority, will cause significant economic harm and job losses, and interferes with longstanding and successful state efforts to protect water quality. Mr. President, it's very clear to me that this rule simply cannot stand, and we have an opportunity here to make sure that that is the case. So if you're concerned about families paying more for their heating and their electricity bills, you should support this resolution. And if you're worried about job losses due to access restrictions and rising energy costs, you should support this resolution. And if you care about states' rights, which so many of us do, or over-regulation by the federal government, which we clearly do, you should support this resolution. Mr. President, I've noted to a couple people today that this is a pretty good day to be debating a disapproval resolution under the Congressional Review Act. It's Groundhog's Day, and this is exactly what the last 8 years have felt like for anyone who's paid attention to the regulations that really were just churned out by the Obama administration. And the SBR rule is a perfect place to start as we sort through the major burdens that the last administration opposed through its relentless regulatory actions. So again, I'd like to thank Leader McConnell and Senator Capito for sponsoring and leading this legislation. Know that I intend to vote for it, and I would urge my colleagues to do the same. With that, Mr. President, I yield the floor and would suggest the absence of a quorum.